Any mentioning in the list? Item number on WPC 3 of 2025.
Why? Not today.
Item number 2 already fixed. Item number 3, WPA 11 of 2024.
Yes, who is for the petitioner? You are for the respondent. Yes, please place the file record. Place the record.
You have to, my lord, I am appearing for the administration. Mr. Lal is appearing for the Union of India. And, we were required to file some reports, my lord, that we have filed. Last time का time मांगा था that's it. हाँ, website बोला था कि उसका इसको देख के आना पड़ेगा. Petitioner had to get back after.
So the petitioner is not present.
The government uses the direction. This is basically my public investigation.
Yes, yes.
Concerning the supply of electricity to the islanders. The islanders are adversely being affected. There's a huge power crisis, my lord. So this public investigation was moved, my lord.
So there is a gap in between the demand and generation of power.
My lord, there's a huge.
As it appears.
Yes, my lord, from the affidavits which has been filed by the administration and central government, my lord, that some steps have been taken. For the agencies who are supposed to implement those projects which is proposed, my lord, they are not a party to the proceeding, particularly the NTPC, my lord. So, my lord,
So you want to implead NTPC as party
yes, my lord, I'll give them a notice so that they can come and appraise this honorable.
But it appears from a previous order passed by that coordinate bench.
My lord.
No, the affidavit has been filed. It has been filed by the bench.
Yes, sir.
It has been filed.
But not as, there's two issues. One is, my lord, there is the rules, my lord, which has been formulated by the central government for payment of compensation on account of disruptions, my lord. If there's a disruption on account of the licensee in supplying the electricity, then the.
So why you want to add the NTPC as party?
Because as per the affidavit, my lord, see the affidavits filed by the Union of India, particularly at page 10, my lord, there's a thin one, my lord, very thin one. Page 10. Paragraph 1, establishment of 50 megawatt LNG power plant.
But there is no paragraph 10.
Page 10, my lord, page 10.
Page 10.
Page 10.
Page 10.
1. Paragraph 6.1.
Here page 10.
Establishment of 50 megawatt LNG power plant, my lord.
Yes.
Answering respondent has directed NTPC Limited to reinitiate the process, at the request of the administration, my lord, to install the 50 megawatt regasified liquefied natural gas based power plant in.
So taking cue from this, you want to add NTPC as party.
This is not the
any objection. Because there is an indication in your affidavit.
It will in fact help the administration also. The court, my lord, gives some directions upon that.
In presence of the learned advocates representing petitioner and Union of India, you are representing Union of India administration.
I am administration.
Mr. Lal is for the Union of India.
Petitioner and the respondents, respondent authorities, public interest litigation is taken up for consideration when Mr. Tabrez, learned advocate representing the petitioner, has drawn attention to a relevant part of the affidavit filed on behalf of Andaman and Nicobar administration.
On behalf of Union of India.
On behalf of Union of India. In order to apprise this court that there is necessity to implead National Thermal Power Corporation as additional respondent. Stop. Next paragraph, on perusing page 10 of the affidavit, this court finds it is necessary to add aforesaid authority. Next paragraph, a learned advocate for the petitioner is granted leave to amend the cause title of this writ petition in course of this day.
Well.
And add National Thermal Power Corporation within bracket NTPC as additional respondent. Stop. Next paragraph. After completion of, after the amendment is carried out, the learned advocate for the petitioner is directed to serve notice enclosing copy of this order and the copy of the writ petition upon the additional respondent by 3 weeks.
No, my lord,
Fortnight.
they have a local office here, my lord. I'll do it within 2 days. Let it come up in the next week, my lord. Some
Well,
elections we can expedite
By
it.
7 days, by 7 or by just a minute.
We can do it by Wednesday, my lord, Thursday.
Well, by 30th,
My lord,
by 30th January 2025, next paragraph, list the matter under the same heading on 4th will be
Holiday.
holiday.
5th.
On 5th February 2025.
Obliged.
Yes, next matter.
Number 4.
My lordship, in this matter, I am appearing for the petitioner, my lordship. Pleadings are complete, my lordship. I pray that Wednesday the matter can be taken up for final hearing.
When
Wednesday, my lord.
this is appearing for hearing,
Yes, my lord, but Wednesday, my
what
lord.
lies in the nomenclature?
No, my
There is
lordship.
no,
Certain
you could not be worried about whether the matter is appearing under the heading motion or.
No. Not required
Yes.
that, my lordship, but certain documents I have to get.
Do you want time?
Yes. That
But
is
tell
the
me straight
reason.
away.
I am asking for time, my lordship.
Well, not today, come back to.
Yes, tomorrow I will be get prepared and I will do.
Not today.
Item number 5. WPCT 44 of 2024.
My lord, in this matter, senior advocate Mrs. Nag is appearing on behalf of the petitioner, my lord. The advocate on record is out of station, my lord. So let this matter may be fixed on 29th.
Very well, 29.
Much
No
obliged.
other.
Item number 6. WPCT 52 of 2024.
Who is for the petitioner? Who is for the petitioner?
I am appearing for the the order for the district tribunal. My lord, I think service is not appeal to service.
Yes, please place the records before also.
When you service has computed.
Yes, what you are trying for?
Come back.
Yes,
I'll serve and come back.
come back. Within which time you will be able to complete service?
Sure.
Let it be adjourned and be fixed on
We'll file affidavit of service and let it come on, my lord,
next week.
whenever your lord.
Next week. As paid for by Mr. Chakraborty, senior advocate, representing the petitioner. Hearing of this writ petition stands adjourned till 5th February 2025, when it will appear under the same heading, in order to enable the learned advocate for the petitioner to complete service and file affidavit of service.
Item number 7. WPR.
Sir, in this matter, I am appearing in person.
Yes,
Can I get little passover? Because I want to appear in physically before this court. So I need little time.
yes, what do you want? When?
I want little passover, sir. Little passover. I'll appear in person. I'll appear physically, sir.
Tomorrow you come back. It will.
Tomorrow, sir. Tomorrow.
In its position. Not today, we are making this matter not today, this matter will retain in the list. Tomorrow, come tomorrow. Not today, matter will retain its position in the list.
Sir, can it be fixed after little passover, sir? After little passover will be enough. Sir, not audible, sir. Not audible, sir. Sir, little not audible, sir. Kindly allow me little passover, sir.
Not today, not today, come back tomorrow.
Thank you, sir. Thank you, sir. Thank you. Thank you.
Item number 8. Here 5 of 924.
For the petitioner is appointed by excellence.
Yes,
I for the respondent, Lordship.
are you ready? Are you ready to do the matter? Yes, yes. Yes, section 5 application has to
Is
be conducted
pending,
first.
Lordship.
Yes. Yes. There is a delay of 1031 days.
1153.
I already filed my opposition, Lordship.
Yes, what's your fair?
The activity is completed from.
Oh, you have filed. I already filed.
Lordship.
Are you opposing the affidavit of this application for condonation of delay?
Even delay can be decide on merit. I am also ready for
What,
argument.
let the appeal be heard on merit?
Lordship.
What is the use of?
My no objection should not be recorded, can be. Can be.
Just. Section 6 of POXO Act, conviction is there. CRAN 1 of 2024. CRAN 1 of 2024. Being an application seeking condonation of delay in presenting appeal preferred against
Judgment and order of.
judgment and order of conviction dated 24th September 2021 is taken up for consideration in presence of the learned advocates representing the applicant / convict and respondent. Stop. We have perused the explanation offered in section 5 application seeking condonation of delay and the opposition used by respondent, you have a state, respondent number 1, which is on record. Stop. Next paragraph. From the explanation furnished in the application, it appears that
We should be granted.
one of the grounds taken by the applicant is remoteness of the area and difficulty in accessing administration of justice thereof. Stop. Stop. In paragraph 4, it is also averred that the applicant requested legal services authority for engaging a lawyer for him, and accordingly, one of the learned advocates obtained documents from the court and supplied to the petitioner. Stop. Stop. It is also stated that in October 2023, senior officer / judge visited the jail and petitioner communicated his grievance that there was a requirement to prefer appeal. And he was advised to approach the legal services authority. And accordingly, legal services concerned authority of the legal services authority was requested to take steps accordingly. So, after the aforesaid steps taken in the matter, certificate copy was applied for on 18th October 2023. Which is located at Mayabandar. No, certificate copy was, please repeat, certificate copy. In the court of special judge within bracket POXO, close bracket, Mayabandar, and which was supplied on 18 November 2023. Stop. Next paragraph. On perusal of the efforts, on perusal of the reasons assigned in causing delay in approaching the court with the present appeal, this court expresses satisfaction. Stop. There is another aspect which requires to be taken into consideration, that this is an appeal against an order of conviction. And if the present application is not entertained merely on the ground of delay, petitioner, applicant shall be the scope of the applicant to test the judgment shall be sealed forever. Stop. Next paragraph. Having considered the aforesaid situation, we are inclined to allow the application seeking condonation of, or application being CRAN, or we are inclined to allow the application. Accordingly, delay occurred in presenting the appeal stands condoned. Stop. Application being CRAN 1 of 2024 is allowed and disposed of. Stop. Let a formal order be passed for filing paper book. For filing paper book. আচ্ছা, এবার CRA এর উপর CRA 5 of 2024 we admit the appeal. Stop. Let usual notices be issued. Stop. A record from trial could be called for. Stop. Next paragraph. Department is directed to prepare requisite number of paper books by 6 weeks after arrival of records from the trial court. Stop. আর কিছু বলার দরকার আছে? Suspension of fine time বলা তো দরকার নেই। Suspension of Next paragraph. Liberty is granted to the appellant to take steps for suspension of fine and sentence upon after the appeal is made ready for hearing, appellant shall get leave to mention the matter for hearing.
Victim may be given a notice by the appellant. Victim of the
Right.
second case may be given a notice.
Next paragraph. Let a notice be at which stage we can disturb it? After preparation of paper book? After preparation of paper book in terms of the direction in terms of the efforts of direction, the learned advocate for the appellant is directed to serve notice upon the victim by fortnight thereafter and file affidavit of service at the time of hearing of the appeal.
Item number 9. Here is 6 of 2024.
My senior is appearing for the petitioner lordship and he is appointed by SLSC. I file an appeal for continuation.
Where is your senior? Written form. In all matters, he should not appear. Senior should come.
Lordship,
Well, not today, tell him to come tomorrow.
lordship, not today.
Time for the respondent.
Yes, same batch of lawyers. So let me see whether senior comes or not. This is also criminal appeal
Lordship, section
and section 5 is pending.
Item number 10.
Item
Supplementary Act number 7 of 2024.
274, I think.
This matter, my lord, there was an addition upon us to find reply in the condonation application, my lord. It is ready, my lord may have it after 2 days, my lord,
But let me see.
or next week.
We are adjourned till 5th. Adjourned till.
Fine.
That's paid for on behalf of the appellant.
Yes, ma'am.
I'm appearing for.
Find out one thing.
Fine.
That there are directions for filing condonation of delay application.
Yes, ma'am.
But where is the report regarding delay? देखिए
My lord is saying.
arbitration matter.
Stamp reporter.
No, there is an order of the coordinate bench to file
My lord.
application. এটা একটু দেখাবেন।
Oh.
Where is the report on delay?
The reporter should.
Where is the
say that-
report on delay? I want a report that already 2 or 3 orders have been passed by the coordinate benches. Granting them leave to file an application, and there is a direction for exchange of affidavits in connection with section 5 application.
Yes, my lord. So, as
but where is the
opposition has been
report?
filed, reply is required.
Yesterday, I was also thinking, where is the report, stamp report?
এটা আছে, আছে। এটা আছে, copy টা থাকে। বুঝতে পেরেছি, দেখো। Just a minute. Just a minute. Let me see this. It will be on 5th of February. In the meantime, I am directing my officer to take up the issue with the department
My lord.
with regard to the report on
Yes.
delay.
My lord.
But affidavit in opposition with the condonation of delay petition was served on 13/12.
If you want to file a reply,
I'll see.
They have already- They have already sought time. The
No, it's
for reply.
pending, my lord, I just.
you will next day you file it.
Fine.
File it. In the meantime, obtain a report from the department. I'm not passing any order. Obtain a report. Where is the report?
Yes, I'm the stamp reporter or yeah, stamp.
Yes, yes, next matter. Simply no, on 5th of February.
Item number 11, 59 of 1024.
I'm for the respondent.
My lord, here, my lord, I'm seeking time to file reply, my lord, to the opposition in the delay.
Listen.
Opposition was already served on 20th. As per the.
Yes, place the record.
There is no direction for reply.
No. In this appeal, there was no delay.
No, there is, my lord, they have filed opposition on, or to the delay application on 20th January.
But delay time taken meaningful. What is this?
Because
Because generally advocates makes calculation regarding delay. That may not tell you with the identification or quantification of time in as it is found in presenting the appeal. এটা শুনুন এইটা দেখুন appeal is filed in delay. What is this? না তো টাইমটা মেনশন করতে হবে, how many days delay. ওরা অনেক সময় ডিলেটাও সবসময় বলে দেবে, কিন্তু সেই ডিলের সঙ্গে রিপোর্টার স্ট্যাম্প রিপোর্টারের ডিলে কিন্তু ট্যালি করে না। এরা তো ক্যালকুলেট করে ইন অ্যাকর্ডেন্স উইথ দ্য রুলস দে উইল ক্যালকুলেট দ্য ডিলে এন্ড দ্য পিরিয়ড অফ ডিলে।
Already served on 20th January. Let it be
Let
other.
it be on day after tomorrow, because I want to sort out this, the system of reporting without indicating the dates. Yes. Adjourn.
My lord, with, I crave leave to submit one thing. See, regarding section 37, the time period, there was lot of controversies were there. First, this international case, it is stated that it is same as section 34, the 90 plus 30, and that was subsequently by constituent bench was affirmed that it should be in of the same drill, 90 days plus 30 days. 90 days is statutory period,
90 days before the different.
and 30 days is the grace period. So section 5 coming into picture only after 90 days. So
far this appeal under section 37 is
concerned, it will be same drill like section 34, that is constituent bench has stated.
So according to you, the period of delay is 90 days.
90 plus 30, 120 days.
The time which has been prescribed for presenting the appeal is 90 days.
90 days, and 30 days is grace period, that is stated in section 34.
So if it is beyond 90 days, then there will be a delay.
Delay.
So the delay has to be quantified.
Quantified.
How many days delay?
Exactly.
Now otherwise we'll find it difficult to dispose of the application concerning the delay, indicating the date. Right.
Madam.
It's simply matters that.
Mine. Mine.
They will raise your,
Yes,
the same period.
mine,
We'll consider.
mine.
Yes.
I just most humbly submit one thing.
Yes.
After the convention of delay, I filed the opposition. Whether is it necessary to file a reply? Because nothing is, everything is on record.
He's playing.
All right.
Opposition to the record.
অপোজিশনটা রেকর্ডে নেওয়া হয় না কিন্তু অর্ডারে নেই।
In
Today you have filed affidavit in opposition.
No, no, today I have filed on the same day,
It is in the
20th
department you have filed.
department, 20th January, and I have some.
Next day, you indicate simply I am adjourning the matter in order to sort out the problem of standing. So that's why come back on day after tomorrow, then I will record that you have filed your opposition. Yes, item number 12, SCT 16 of 2024.
My senior is appearing on behalf of petitioner, my lord. I'm praying for not this.
Not today. Item number 13, SCT 18 of 2024.
Same, my lord, praying for not today.
Item number 14, MT 16 of 2024.
In my lord, I am appearing for the appellant, my lord.
My lord,
Here, my lord, the
15,
party.
I
has
am
to be-
appearing for the added respondents in the writ petition. We had filed an application for impleadment which was allowed. We were added as respondents. Now we've been served, but funnily enough, in the mat, I don't find our names. So I'm not sure who I'm appearing for.
With the added respondent.
We were added in the writ petition.
You were representing him.
In the writ petition, the two added respondents over there, Kalapani Auto Union and Island Auto Union. But their names don't appear in the appeal. So probably my learned friend has to just amend the cause title to add me in,
Yes.
and then I would be appearing for them.
Where is the order? On
And
which
it's
date
page
you follow
15.
the amendment of petition?
That order, I'm not sure, but page 15 is the impugned order. My lord will find my appearance at page 16.
Not anywhere. Yes, but where is the order? Was there any order passed by the?
There was a specific,
my
no,
To
by
add,
the writ court,
read code, there was a direction to add
to add me. Kindly see page 16, it will be clear.
page 16 of the appeal.
Of the, this is the stay petition.
Stay petition.
Page 15 is the impugned order. Page 16,
Just. Yes, page 15.
Oh, added respondent.
Page 15.
page 15 is the impugned order. At page 16, my appearance is recorded for the added respondents. And
Added respondent in which writ petition?
this was,
Now there might be an omission on the part of the appellant while drafting the.
that's all. It, and I can understand why.
The original, the report relating to the writ petition is not before us.
Yes.
So whether the writ petition has added those parties as additional respondents.
No, as per page 2, the cause title, there's a bit of, so writ petition, I'll show you.
Page 43.
43,
Here it is not. there.
here my name cannot appear because I was not at that point of time a party. But I have filed the application thereafter. No, because my application was filed to implead me as a party. That impleadment has happened subsequently.
But at the time of presenting the stay application, the amended writ petition should be.
Could have been there. So that's why I'm saying.
He's appealing for the writ petition.
I am appealing for the writ.
Yes, Mr. Bindu Gopal.
My lord.
Yes.
So my lord, I don't know whether he was added as a respondent or as an intervener. Or as an intervener. I don't know, my lord.
Judgment on appeal.
My lord.
Petition.
My lord.
For added respondents, so and so learned advocates.
My lord.
Page 60.
My learned friend has filed this appeal along with the writ petition which was initially served to my learned friend, not with the amended application. So my lord, he may be given liberty to correct it, incorporate the respondents.
So you need to.
No, I have done it in this.
The writ petition, copy of the cost title of the writ petition, amended cost title of the writ petition upon.
That I can do. Yes, yes, that I will.
Otherwise, he-
My lord, my lord.
Make amendment of the appeal and the stay application.
My lord, my lord, my lord, my lord. So let it be in the next week, my lord. I will just. Do it.
In the next week, you will serve the amended copy.
No, no, within this week I will serve. Let the matter appear in the next.
As a respondent in which petition?
WPA 11. WPA 11. That was the
WPA 11.
of 24.
Respondents in the writ petition. In WPA 11 of 2024. Submits that though his clients were, how many persons were added?
Two unions, man. Two unions. They are also auto unions.
Representation submits that though two auto unions were implicated. Were implicated as additional, were implicated as additional respondents. But in the appeal of the application, there is no reflection that those unions have been made as fines. So, next paragraph. Learned advocate representing the writ petitioners respondents. Yes, writ petitioners respondents. In WPA 11 of 2024 is directed to supply copy of the amended title of the writ of the said writ petition upon the learned advocate representing the appellants by by 31st January 2025. So, on receipt of amended post title of the writ petition of the same writ petition, leave is granted to the learned to the advocate on record for the appellants to amend the post title of the appeal, to amend the post title of the memorandum of appeal and the connected stay application. Section 5 is there.
No.
And connected stay application by 6th February 2025. Next paragraph, list the matter under, list the appeal and stay application under the same heading on 7th February.
Good.
So only in one writ petitions out of 4 or 5, this.
Yes.
This problem.
This one writ petition,
In one
WPA,
writ petition, only these two auto unions were added as
correct.
part.
This
In
one,
other writ petition, this was not
no,
done.
I'll just clarify. The writ petition 11 was a challenge to certain policy decisions that were taken by the administration. The other writ petitions were by individual auto drivers who had received some show cause notice or some case was registered. So that was a separate issue. 11 is the main.
Union, laid a challenge.
An auto union laid a challenge to the policy and implementation.
They were added as a party response.
No, so those two who had come are actually inimical to the writ petitioner's perspective. So that is one auto union which has one perspective. We are actually countering their perspective and the administration is in the middle.
Querying auto union.
The policy is being supported by the union being represented by Mr. Kabir.
Oh.
And the writ petitioner is.
Yes, they have challenged the policy.
Great.
There is section 5, Mr. Whether this section 5 is.
That is what I have informed Mr. Chakravarti, that there is a section 5. I don't know whether I.
Where is disposed of or not, my lord, that will. Section 5 disposed of, I think.
Give me the section. That is in connection with, no, have you preferred separate appeals?
No, my lord. This
Why
will be
not?
one of them. Because my lord, it is, the order is substantially in
So
our
you have preferred
favor.
acting in connection with which writ petition?
My lord, we have the first matter itself, my lord.
But if the
What
order
is the
is,
indication?
My lord.
but if my lords interfere with the order, the rights of the others will also be affected.
No, my lord, this is. No.
There is some gap because if It's a common order covering all, but if your lordship sees the cause title, the second respondent after that is set out. So it's not clear who they were. So-
If we proceed on this premise that yes,
Because the
it's a common order,
order-
but you have preferred appeal in connection with which writ petition?
WP, my lord, 11 of 20.
That is the parent
That is
proceeding.
the first writ.
Because my lord, the order is such.
Do one thing. Appeal, memorandum of appeal, see, section 5 application is clear.
The order is
In
substantial.
on all the pleadings,
Yes.
amendment is.
The order
required to be
is,
carried out.
is substantially in favor of the administration. There is only one aspect in which the learned single judge has held otherwise. Only that limited aspect is challenged, my lord. in the-
So that's why so far appellant is concerned, you are agreed by that part of the.
Only a
Judgment.
one part of the judgment. Otherwise, it is in favor.
Taken out an appeal. Appeal is allowed. And if your appeal is allowed, then what will happen to the orders passed in other petitions?
My lord, only on that.
Their right will be affected.
Right will not be affected because my lord,
Appropriate proceeding.
No, may I just clarify this? It would not be affected. I'll tell you, Lord Suspect. This dealt with a particular policy by which only islanders could apply for auto permits. This was the heart and soul of the case. Now, the single bench made various points of observation. Out of that, the one which the administration is challenging is the one with regard to islanders because the single bench made a cutoff date. They said up till today, all the permits issued will follow the conditions that exist. But from today, all the permits being issued, you can't ask for an islander identity card. That means anyone from mainland can also come and operate an auto. Therefore, the other writ petitioners in the other writ petitions had challenged the position that existed prior. That part of it, the single bench has maintained. Therefore, whichever way this appeal goes, their rights actually can't be affected because they never challenged this order. My lord has got me. The single bench said whatever has happened up to 12th of February 2024 is correct. Going forward, you will not do this. He has challenged that part, that going forward not do this. But the earlier part,
Henceforth, it will not be done.
yes, so the earlier part remains as it was. They have not challenged that order. Therefore, today, even in the appeal, if today your lordship allows the appeal and says that no, even going forward, these conditions can apply, they cannot be affected because they were part of the regime that existed before the cutoff date. So technically speaking, they will not actually be affected. Because had they challenged it, that even prior to the cutoff date, that part of the order is under challenge, then I could have understood. But that part of the order is not under challenge.
Let the amendment be carried out.
My lord, when your lordship takes it up, we will clarify the situation absolutely.
yeah. The other name, sorry, that-
Item number 15, MET 70 of 2024.
My lord, senior advocate Mrs. Nag is appearing on behalf of the appellant, my lord. As she is out of station, so let this matter may be fixed on 29th.
This week, she will not be there.
She'll come by 29th or 28th, my lord, tomorrow evening.
Till on Friday.
Much obliged.
No order on Friday.
Well,
Item number 16, MET 76 of 2024.
I'm for the appellant, my lord.
I also preferred an appeal against the said order, part of the order.
I
my lord.
also
So-
challenge the part of the order, my lord.
It is an
Because the
order.
Earlier, the Labour Commission is also. May please, madam. The earlier Labour Commission is also party to the proceedings, but as now they have been going to engage a new council, it seems, my lord,
They are
because
going to.
engage another council, because earlier senior council Satari Chakravarti used to be up here. I am for the appellant, my lord. I just pray this is be taken on 29th, I just give him a notice to the Labour Commissioner and that
So there
appeal.
is a change of executive. So
Yes, ma'am.
Labour Commissioner is-
Yes, ma'am.
But no, let it be in the next week because I also preferred an appeal. Both, there is an order that
Being
both
agreed by the order.
part of the order, only part of the order. There was an order that back wages will be paid 40%. I am asking for 100%.
100%.
100%.
Same period is made by the appellant in this.
No, no, we have
They
challenged the
prefer an
40%.
They actually preferred an appeal, thereafter complied the order.
The remaining part has complained, my lord. The 40% wages has to be paid. Those the period which they have not worked.
The code below for the land single that is directed
For-
40% of the back wages.
Yes, my lord.
You want 100%.
100%. They said
What
the
is
period-
what is the crux of your appeal?
My lord, my Kapil, my lord, that during that period they have not worked. So the no work, no pay principle.
No, are you on the, what is your stand on the point of 40% of 100%?
No, 100, we say that 40% is not entitled, no, because we have given the duration of the break of service from the date when they have been disengaged. That has been continuity has been given.
So what you have paid?
We have paid the arrears of salary as of 130th, everything has been paid, my lord. Around and 7 lakh odds have been paid. Now the 40%, it was pending before the labor code before the reconciliation process. But the 40% salary which those period which they have not worked for a period of hardly 5 to 6 months duration, not that period they have not.
Paid at a rate of 40%.
No, no, my lord, we have paid the arrears and the payment for the period which they have worked. For this period, they have not on service.
So on relating to those periods when the worker did not.
We have not paid
work,
40%.
not-
No, we have not paid. That's we agreed by that part. We have preferred an appeal. But remaining part for re-engagement with their continuity of service, that has been done. Only the part whether 40% they are entitled to be paid during that period when they have not worked.
If the amount is payable at a rate of 40%, they would, in that event, whether something more is payable to the workers.
But, my respectful submission is that, my lord, the principle of that no work, no pay will be applied, my lord, because during that period they has not rendered the service.
He's on it.
Yes,
Current footing.
yes.
Answer.
So let the matter be, let my learned
If
friend
they-
correct the order.
My appeal is,
Appear along with the.
Yes, there is an order of.
The appeal has not been preferred to you.
No, I preferred, my lord. There is an
there is an
order
order, earlier this honorable court has passed an order.
to tag both the appeal. So let it be,
Your appeal is Mat 1 of 2025.
my lord.
So is it not on board today?
No, no, my lord, it is not.
No, it's not.
It's item number 16.
16, my lord.
Let us pass it on.
Which could have been already ordered cross.
Land advocate representing the appellant. And represent the appellant in intra-court appeal being NAP 1 of 2025. Submits that in terms of the previous order, dated 8 January 2025, both the appeals and the connected stay applications should be heard together.
My lord.
So next one. Let the appeal being NAP 1 of 2025 be tagged with the present appeal and be included in the list under the same heading on on 29.
My lord,
Yes.
request, my lord, let it be on next week, but they also not serve the copy of the mat. I will issue notice to the labor commissioner. Next week, any date subject to my lord's acceptance.
6th February.
Yes, yes. They may be directed to serve the copy of the appeal also.
Next paragraph, in the meantime, non advocates representing the appellants are directed to complete service.
Yes, yes.
of this
Oblige,
And file affidavit of service of that.
oblige.
My lord, I will serve upon my learned friend, my lord. Otherwise,
No issue. Oblige.
So. Upon the respondents or the non advocates representing those respondents.
oblige.
Item number 17, Mat 3 of 2025.
I'm told by my learned sister that she's ready with the matter.
My lord, dispense with its a intra-court appeal. Dispense with the preparation of paper book. Based on the material on record, I can proceed with the appeal. Tomorrow or day after, any date can be taken up for these two appeals. It's a common question of factual law involved.
Both the matters.
Both the matters. Both the.
before the trial court affidavits were exchanged.
Yes. No, it's basically.
How do you cross the hurdle of having other pieces of land?
No, Lordship, schemes provides, even if, just one second. If the scheme provide, no, under the scheme, if I'm having another property, I'm entitled to get the benefit of the scheme, but the limitation would be mentioned in the scheme. It's not that I'm having a landed property that will not procure me. Scheme itself says. But the writ court said that it's a high power committee who is in appointing authority. That's not the law. I'll show that scheme, very scheme. High power committee is the first authority who makes an inquiry, prepares a list, forward it to the revenue authorities. Here in the present case, it was done so. Deputy Commissioner recommended my case. It's ultimately the Lieutenant Governor who has to approve my name and issue a license. That's the point. I would place the scheme. It's all with regard to the interpretation of scheme laws.
When you want to argue this matter?
Tomorrow, day after.
Tomorrow.
But the preparation of this paper book may kindly.
Not required. We will hear you and if we find that his preparations are not required, but whether the affidavits are part of record.
In the memo, I cannot annex it. That's the not liberty may kindly be granted to use those pleadings at the time of hearing. Not grants that liberty. Those people.
But where is the stay application?
There's no stay as such.
Where is the stay?
There's no stay as such. I'm occupying. There's no scope for any stay, Lord.
No, if there is no stay, scope for any stay, and if the all pleadings which were used before the land single judge are not before us, then you have to file a paper book.
That's the thing.
Otherwise, if you had, if you would have filed the appeal along with stay application, including all the pleadings, then we could have heard the appeal at the motion stage.
Then this has to be taken up by way of an paper book only, because these papers need to be brought in. If one not calls for the writ court's proceeding entire file, it appeals to.
If it is only on memorandum of appeal, then we have to give direction for paper.
It's memo.
Had you filed an stay application incorporating all the pleadings which were used before the land single judge, then at the motion stage, at the application stage, we could have disposed of the appeal and the application.
No, in such case, I'll prepare the paper. These pleadings need to be brought in. That's what I'm saying, If not.
It accords application for appropriate order or to give all the
It's all
documents and record pleadings.
It's all rest with the interpretation of the scheme. It's all rest with the interpretation of the scheme. It's what how scheme is. It's not me and you interpreting.
MAT 3 of 2025 is an intra-court appeal preferred against order dated 11 December 2024, passed on the connected writ petition. Stop. Mr. Jaipal, next paragraph. Mr. Jaipal, learned advocate representing the appellants or representing the appellant, submits that there is no scope for passing, there is no scope to stay the order under appeal at this stage and let the appeal and the appeal needs to be heard finally. Stop. appellant is directed to file requisite number of informal paper books by 4 weeks from date.
No, no, on Monday. It's very, pleadings are very short.
Very-
If I could find, I could prepare it, I'll file, prepare.
By Monday,
This can be taken.
by Monday, and by Monday, stop. Let the next paragraph. Notice of appeal stands waived since the petition. There are no other respondents.
For all madam appeals,
They can also.
for all madam appeals.
He is Secretary, Deputy Commissioner, then where is they?
No, he is.
Representing all the respondents.
Response.
Acha, just track of the last line. Since all the respondents are represented, notice of appeal upon the respondents stands waived. Stop. Let the appeal be registered if it is otherwise informed. Next paragraph. I've said by Monday. List appeal for hearing. But Monday will be the holiday. By
Next one.
by just a minute.
Yes, sir. Consecutive Monday, Tuesday holidays, yes.
3, 4, by 5th February 2025. Stop. Next paragraph. List the matter under the heading appeal or under the heading hearing on 7th February 2025.
Lord, may I say one thing?
Yes.
7th would be the second of the circuit because the last day would be.
In that
10th.
event, you file the
Yes, yes.
no, it is to be registered that the certain formalities are there.
By-
Why you have not filed an application?
By this Friday, I'll prepare the paper book. So that should some, instead of Monday.
Please read the first part of the order. Please change this paragraph. The learned advocate representing the appellant undertakes to file a requisite number of informal paper books by Friday,
31st.
31st January 2025. Stop. Then appear under on 5th February.
Yes, I'm grateful. I'm grateful. I'm deeply obliged.
Next, the same matter.
Same on.
Just a minute, let the record be placed.
Item number 18, committee 4 of 2025.
Date of order is same.
Same. Two separated petitions, two orders, two intra-court appeals, which are before me.
And all the respondents are represented by whom?
Yes.
By you. Same order.
Obliged.
Item number 19, committee Arbawad 1 of 2023.
My lord, my senior is appearing for respondent authority. We have filed our affidavit in opposition and served upon the petitioner.
My lord, 2 weeks time will be given to file a reply, my lord.
Affidavit in opposition in connection with stay application.
Can 3.
Can 3, my lord.
What is can 3?
Some 5.
Therefore,
Release of amount.
Release. Oh, why it is your application?
Yes, my lord. Actually, Advocate Ajay Maji is appearing on this matter, my lord. Due to some personal difficulty, he is not appearing today.
The
So,
amount deposited at the time of admission of appeal. You want release?
My lord.
Application for release of it.
এই
Arbitration
যে
procedure.
appeal-টা
হুম।
ইয়ে করার সময় সাড়ে 7 কোটি জমা দিয়েছিল।
Who is representing?
My senior Mr. V.D. Shivabalan is appearing.
Now the respondent has filed this application to withdraw the amount.
My lord.
So if you have lost the matter right up to Supreme Court, then why you are filing an opposition?
My lord, in this matter, the Union of India is to file review application. So we have filed that part on our affidavit of review.
So have you filed review application? Have you indicated in your application opposition?
My lord, this matter, my senior is appearing for the respondent authority. I cannot proceed with the matter.
Who is your senior?
Ajay Maji, my lord.
He has difficulty.
Yes, my lord.
And the advocate representing respondent has paid for accommodation to file affidavit in reply. Stop. Let affidavit in reply be filed by weeks from date with an advance copy upon the learned advocate representing the appellant. Next paragraph, list the matter under the same heading before the next circuit subject to convenience of the bench. সেই জন্যই শিশুগুলো কনস্ট্রাকশন
Item number 20, deputy 2 of 24.
For the appellant, I pray day after tomorrow.
Well, today adjourned for today and tomorrow, day after tomorrow.
Item number 21, WPCT 234 of 2021, 2019.
In terms of the order of the court, they have served me the copy of the petition, my lord. I will go through it because it's an old matter, whether all the papers are there or not.
You are representing the writ petitioner,
Respondent.
respondent writ petitioner.
No, my lord, I was an applicant before. the
Applicant,
tribunal.
original applicant.
Original applicant.
Oh, WPCT. Tribunal application.
2019 matter.
Come back on remand.
So you are the original applicant,
Yes.
Supreme Court has remanded.
remanded the matter. Now, after the remand, then whether the pleadings are complete.
So
Pleadings before the tribunal was complete.
Tribunal.
tribunal was completed, they have.
So what for you are praying for time?
Well, they have supplied me because it's an old matter. I don't have the brief. I requested my learned friend,
When the order of remand was passed by the Honorable Supreme Court.
last month perhaps.
Oh,
19th November 20. But there is no request or. There is no request for deciding the matter expeditiously or anything.
Where is the order of the Supreme Court?
Standard last time, I can give.
Just a minute. Yes, just a minute. Yes, it is there. It is there. Definitely order. Appeal, order first. Since you were appearing for the original appellant, original applicant before the tribunal, so the pleadings are with you.
My lord, actually, this was 2019, it was decided by court 20 or 21, my lord. Thereafter, my lord, client taken away the brief. Now client did not able to locate the brief. Thereafter, I requested my learned friend, my learned
Yes,
friend-
Mr. Chakraborty, when you,
Handed over, my lord, but I have to go through whether all the documents are there or not. That is time, my lord. There is some paper missing on that.
so come back next week?
Yes, my lord, next week.
Not this week.
Yes.
Not this week. That is in connection with separate.
Yes, my lord. So the earlier order was in earlier proceeding, but
But the coordinate bench proceeded on the premise that it is in connection with the same proceeding.
bench proceeded in the manner that there are two separate proceedings, but at the time of.
But the Honorable Supreme Court has held that this is in connection with the separate.
Yes, my lord, that was wrongly actually written, but while considering the application, the Honorable High Court was of the clear view.
Well, let me hear both of you.
Well,
Item number 22, deputy one of 2022. Item number 23, WP 3 of 2022.
Three. Mr. Vinu and myself are your lordship special officers. This is a matter relating to the suo motu writ petition of the condition of the NH4 that runs from Chiratapu in the south up to and ends at Lamia Bay. So this matter has been pending now for almost 2.5, 3 years. The situation has been basically that this court has been monitoring from time to time the situation with regard to the.
How the work was progressing.
So as of now.
It was Justice Talukdar's division bench, this
Justice
issue was.
Talukdar and Justice Mohanto who had initiated it, it was part-heard with them till both of their lordships had retired. Thereafter, every consecutive bench that comes here takes up the matter in the first week, so that any issues with regard to the highway can be raised and any work that is required to be done can be brought to the court's attention. Now, 2 circuits ago, Justice Mantha's bench, the bench presided by Justice Mantha, expanded the scope of this to also cover the roads of the EPWD and municipal corporation within the Port Blair municipal area and in other parts of the islands. So not just.
So the road construction work is going on in front of our.
So there are many places.
Our bungalow, that is also part of this project.
It's not part of the project. It is within the scope of this petition now. Because
The dimension has been widened.
initially this dealt with NH4 only, which comes under NHIDCL, which is represented by Mr. Shannal, who's appearing in the VC. Now it is also covering all roads within the Andaman and Nicobar Islands, whether looked after by APWD, PBMC, whichever, by whatever name the authority is known. Now, the situation as it stands is, we have there are two parts to it. The first part is maintaining the road, which is already there. The second part is certain parts of the road are in very bad condition. And it is something everyone knows that once the monsoon starts in Andamans, the rain is torrential.
The situation will be wretched.
Absolutely. The parts of the road just don't exist. And as your lordship is aware, so far as NH4 is concerned, it is a lifeline from the south to the north, and everyone is traveling that. You cannot always have helicopter or ship.
It goes through Varangat, then Biglipur.
Yes, it will start from Chiryatapu at 0 point. From Chiryatapu, it comes up to Pratrapur, turns towards Sipighat. Then it goes up to Jirkatang. The Jarwa area is there. Then it goes up to Middle Straits, where you cross the Jarwa area and you come to Middle Strait. Then you cross to Baratang, Rangat, Kodamtala, Mayabandar, Diglipur. So the entire road stretches 332 kilometers and ends at a place called Lamia Bay. Now, as it stands, we currently are facing a situation with regard to 3 places on the road, actually 4. The first is a place called Baratang, where for a long period of time, over 6 years, no work was actually executed. Now the contractors have been changed, and through this monsoon, they have been keeping it motorable. And the expectation is that with the new contractors, that work would probably be done for the.
So work is in progress. What is your stand?
As far as the special officers are concerned, we have not yet made an inspection. Our last inspection was in last year, May or June. Thereafter, until the court directs us, we have not gone. But every circuit, the NH officers, they file a report that what is the work being done. So they have now filed a report which I have received. So far as the the report is probably on.
Yes. Which paragraph?
Annexure A at page 5 kindly sees.
Yes, Annexure A.
So number 1 is Chiryatapu to Jirkatan, that is okay. Number 2 is a problem area.
Just number 1 is 0 to
107. So basically
up to Jirkatang.
Up to Jirkatang, and thereafter you cross up to the
Middle Strait
area. Now the Middle Strait Bridge, here this bridge has been under construction for many years, but it was not getting done. Now they have terminated that contractor, new contractor is there. The bridge has been redesigned now because there is some aspect. So the report says it's in the early stages of finalization of design and drawing. And after this, the work would be started. The completion date has been given as 25th of February, 2026.
So after 25th, beyond 25th February 2026, there should be one inspection, not now.
2026, madam.
2026.
Next year. So right now, what is the status of the work they have said? But last we have seen, it was the piling was done on the shores in the middle of the sea. The piling was not completed and they wanted to go for that redesign, which now they are saying is in the stage of finalization. So this till 25th February 2026.
At the same time, it is reported that currently the contractor is a contractor is in the early stage of finalization design and drawings and mobilization.
Because it has to be, they want to redesign the position so far as the bridge is concerned. Now the other side of the bridge, at the next page, my lords will see.
But since considering the report as you have placed before this court, this report has been filed by the administration.
NHIDC.
NHIDC.
Mr. Sanyal is representing them.
So we think that there's some time should be given to them.
So far as the bridge is concerned,
and thereafter, if after 2 or 3 circuits, or after a period of 6 months, another inspection is required to be.
That is only
find out the progress of work.
No, that is only so far as the bridge. The next page, those are the 2 areas which were actually requiring serious attention, 3 and 4. These were the 2 areas which were really in very bad condition. Baratang and Rangat. So here we are informed that work is in progress. 3 and 4. Here what had happened is the contractor had not touched the road in the last 6 or 7 years. So it was in a terrible condition. This court used to describe it as horrendous. Now work seems to have started with new contractor. Now, so far as these are concerned, the officers of NH had personally appeared and said May 2025. So we are end of January, February, March, April, May, 4 months from now.
Against serial number 3, you are saying?
3 and 4, when their officers appeared in person in the last
So that
circuit,
is not in the report, the May 2025.
when they came in person, when they were asked to appear, that time they had
Just
said
let
that
us,
it
let
would
us go
be.
through the last order. part by
Well, in the order sheet, your lordship perhaps will not get it.
Just a minute. Just a minute.
My lord would see the order of 6 November and 6 December.
This is 7 January order.
No,
part
that
by-
comes later, but
Just-
6 November, 6
just-
December.
Just a minute. So the another report may come up in terms of the order passed
First
by the
week of
coordinate
February.
bench on 17 January
First week
2025,
of February.
February.
That is now, that is so far
Because
as the.
this report, Mr. Kavi,
So far as APWD is concerned.
Yes.
That's a different issue. This is so far as NH is concerned.
No, since there are certain works which was going on for laying down the cable.
No,
So-
that part is separate. I'm coming to that, my lord. This part deals only with the NH. This part APWD has nothing to do with. So this report, 3 and 4, Baratang Rangat, these stretches, it is looked after by NH. APWD has nothing to do. The APWD issue is a separate issue. The APWD issue is that there were several roads after the monsoons which were in very bad condition. My lords had come, had personally observed the situation and had added those into the scope of the writ petition. Thereafter, we, as in the special officers, have never made an inspection, so we do not know. However, we were given that liberty to bring to the attention of the court. Now, in the course of the last 2 weeks, I had personally noticed certain things and I had been informed by mainly school parents that there are certain places which are being done up for this cable laying work
The roads which are coming under the jurisdiction of
of
APWD.
APWD. Now, that is in fact within the town area. So, my lord, I had personally gone and seen some of these places. When I submitted it orally, the APWD had taken objection saying that not everything is oral, I should indicate something. Then I filed a report with photographs. Now that situation is what they are doing is they are laying cables along the side of most of the roads in Port Blair. For that, a hole is dug and the cable is passed through. But once the cable has gone through, there are massive holes which are intruding into the middle of the road, surrounded by a mountain of
Which
rubble.
is generated due to laying of cable.
Now the
So
problem
that
is
holes are not filled up. That
no, that was the problem. There are accidents.
because there was an
happening and-
excavation work
Yes.
due to laying
All
of
I
cable.
did was I brought it to the attention of the court that this needs to be addressed because there have been several accidents, especially in the school areas, on hill areas. My lord will find on 2 sides of the road, it is a huge crater surrounded by 1 meter of rubble. Now, a school bus flying and a car coming from that side, I am personally experiencing even, it is a very dangerous situation. So I brought this to the attention of the court with the intention that APWD deals with whoever the contractors are because APWD is looking after it. At least let them fill it up so it is not a danger to motorists and navigation. Then the road surface can be done. The reason was that this can also be looked at while filing the new report in February. Now, on that occasion, Mr. Chakraborty also had appeared and he had submitted that within 2 or 3 days, these would be dealt with. I regret to say that In a month, nothing has happened. After that report was filed by me and those orders were passed in January.
Do you have the copy of the order dated 17 January 2025? Now, paragraph 4 talks about one report. A
Madam.
report has been filed by the special.
That was
report.
I have filed with photographs.
Whether the report which is before us today, this is filed today.
This is filed today by my learned friend appearing for NH together with Mr. Sanman.
This is National Highways Authority.
National Highway Infrastructure Development Corporation Limited. Here there is no NHAI, it is NHIDC.
But today you are demonstrating with regard to the present condition.
No, I'm bringing
condition of roads, especially which comes under the jurisdiction of
Yes,
APWD.
Yes, so the issue which I have raised in the last circuit is with regard to APWD. With regard to NH, they have filed the report. This is the situation they are saying as to the status of.
One report by this authority, this is National Highways and Infrastructure Development Corporation.
That they have filed today.
That is with regard to the road which is stretching
NH
through Baratan, Gilgam and right up to
a place called Lamia Bay, which is after Diglipur.
Right up to Lamia Bay. Now, this is one aspect of the matter. Now, there is another report which has been referred to, that is the report filed by you, being the special officer. And the report, which is just a minute, with February, in this regard, we are informed that the report is to be filed by the respondents by February 2025.
That they will file.
There are three categories of reports. One report is today before us, that is by the authorities, National Highways. Then another report which was filed by the special officer. Then the report which has been referred to, that will come up in the month of February 20. That is to be filed by whom?
APWD.
But perhaps that report would include or would reveal the road conditions, especially in town areas.
Yes.
In and around Port Blair.
Yes. So that is why I highlighted those aspects.
So what steps you are taking, Mr. Your authority is taking, APWD is taking to fill up this crater, which has been generated due to laying of prevalent fibers.
Last occasion, my lord, we were granted leave to respond to that also in the report, my lord, which will file this month in February.
My lord, may kindly have my report. It will make it clear. I was compelled, I'm sorry to say, to bring this on record with photographs because my oral submissions perhaps were not enough.
My lord, the court has granted us permission to respond to it by
response and affidavits and records are all fine, but kindly see the situation that the citizenry in Port Blair are facing. It has to be addressed.
Predecessor bench has already granted us an opportunity to respond to this issue, my lord. It's been subcontractors are doing it, my lord, and this we had pointed out.
No, you want that this work should be carried out in a by giving certain importance to this particular work, and it should be completed expeditiously.
This work is being carried out by private subcontractors. They had written to us that we will.
The swearing of cognizance has been taken by the court. You should give some amount of importance to this to this entire project, so that the routes can be maintained and prepared properly.
And not so far as this.
Very well, you will get opportunity in terms of the order passed by the coordinate bench on the last occasion, and you will file a report. But in the meantime, you apprise this court that what are the steps you are taking to fill up those holes, which were created for laying cables and these other things. Fibers, cables and fibers.
My lord, then my lord, we'll come back, my lord, we keep it whenever you lordship. I will take instructions and orally, my lord, apprise the court, my lord, what is the status?
At least the court should be apprised of their present development, because you are getting time up to February. So in the meantime, what are the steps? Because the pedestrians as well as the persons who are using this road, they are finding it difficult, as it appears from the submission of the special officers.
We will address it, my lord, whenever your lordship deems it appropriate, my lord, may fix it, we come back with instructions.
We will take instruction next week.
Next week.
Yes, don't disturb this. You are not a party to this matter.
Yes, I have submitted a application.
My lord, on
Because I have submitted clarification in this matter, present matter, in this.
Not at this stage it is required. Let me hear Mr. Chakraborty on the points taken. Yes. Yes, you filed the application, it will be taken care of in the next state.
My lord, may I only add, there is nothing more to add, whatever has been submitted.
Yes.
This part, this breach part, Middle Creek breach part, it was, my lord, a specific query raised on the last occasion. The delay was
Your parties, you are representing national
NHIDCL.
development. So
Yes, my lord, only
trying to find out the present situation so far roads which are maintained by APWD.
oh, my lord,
Which is not comes under your jurisdiction. So it is to be
Fine.
made in and around town areas where the residents of this town are facing difficulty while commuting. So therefore, this court wants the present situation of the land advocate representing APWD will get time to file report. But in the meantime, what are the developments which are taking place? Court wants to know from Mr. Chakraborty representing APWD.
my lord.
APWD and PBMC, my lord, both. APWD and Port Blair Municipal Council.
Municipal Corp. Who is representing Port Blair Municipal?
My lord is probably has understood also one more thing. This is not really an adversarial situation. This is where the court had wanted Mr. Chakraborty for the administration.
It's not an adversarial litigation.
So everyone would try and get that degree of
So that there will be an overall improvement in the condition of road.
that is the main thing.
That is the approach.
So that is why Mr. Chakraborty has been appearing for both.
At least one matter that you are not. Me,
I don't fight with anyone.
In terms of the previous orders, a report in the form of affidavit is affirmed on January 27. Today it has been affirmed. 27 January 2020 or affirmed.
Today it has been affirmed, my lord.
On 27 January 2025.
And copies been circulated.
On behalf of National Highways and Infrastructure Development Corporation Limited, within bracket NHIDCL, close bracket, is taken on record. Stop. One of the Mr. Kabir, one of the joint special officers, submits that on behalf of the special officers, a report was filed dated 15 January 2025, which is on record in order to demonstrate before this court the worst road condition. So for the roads which are maintained by APWD and Port Blair Municipal Corporation. Port Blair Municipal Corporation. Council. Port Blair Municipal Council. So it is reflected from the order passed by the coordinate bench on 17 January 2025 that due to laying of cables/fibers on such roads, pedestrians and the commuters are facing difficulties while using this road, and it has become menace. Stop. In order to remove the difficulties which the residents of town areas are facing, immediate construction and repairing works are required to be carried out for proper maintenance of roads, which comes under the jurisdiction of APWD and Port Blair Municipal Council. Stop. Next paragraph. Port Blair Municipal Council and APWD are represented by Mr. Chakraborty, Learned Senior Advocate, who has apprised this court that in terms of the order dated 17 January 2025. They have time to file report up to February 2025. Stop. Next paragraph. We are aware of the directions contained in the order dated 17 January 2025 passed by the coordinate bench. However, considering the importance of the issue involved in this writ petition, this court directs Mr. Chakraborty or requests Mr. Chakraborty to apprise on the next date what are the steps which are being taken by APWD and Port Blair Municipal Council for quick maintenance and repairing of the road. Roads, stop. Let the matter appear under the same heading. On 7th February 2025. Yes.
In respect of this issue which has been raised by Mr. Kabir, this regarding the excavation work because of laying of the
Optical fibers, yes, cables.
optical fiber. Otherwise, if my lord says that we have to address all the issues, why not then?
No, I have said that due to laying of cables and fibers, this issue has been, has cropped up. Yes. You will get time to file report by February 2025, but in the meantime, court wants to know from you what are the measures the authorities are taking.
I have submitted clarification. It could be in fact, if the road is found.
This is due to, this is on the basis of the suo motu cognizance of the issue by this court. Let the court deal with this issue.
Yes.
Sorry, intervene in all matter.
Grateful, my lord.
This is the issues on the basis of the suo motu cognizance by the court. So allow the court, permit the court to take care of the issue. We are not concluding the issue, that's why. And we are widening, we are making it wider in order to rope into all other category of roads. So have patience and permit this court to make certain progress with regard to repairing of roads. Yes, next matter.
Grateful, my lord.
Please sit. This mandated by the Land Council for the response with the evidence to us.
Documents with Hindi language.
The appellant. The land advocate representing the appellant has prayed for extension of time to file supplementary affidavits. Supplementary, right? The land council of evidence has submitted. But there is a direction to file supplementary affidavit, not paperwork. Let the same be done using terms. So you want to file a paper in the form of paper. What I've said, affidavit in the form of paper book as directed by the coordinate bench on 15 January 2025. In order to incorporate other materials, including evidences. Stop. The time to file such paper book stands extended for 2 weeks. For 2 weeks. Or time to what I've stated. Such paper book is extended by 2 weeks. Next paragraph, list the matter before the next available circuit, subject to convenience of the bench. Next.
Submission on the last petition also, a request of the ground for extension of time. When is that Kerala constituent, I have to file my affidavit and reply. So
It is pertaining to,
I'm one of the petitioner, I will have to file my affidavit and reply. But my client.
affidavit in reply in connection to which pleading?
Against affidavit of-
In connection with the stay application?
No.
PIL, man.
PIL.
No stay. Wait for it, submit
Land advocate representing your Sellers Union of India. Land advocate representing the petitioner has prayed for further extension of time to file affidavit in reply on the ground that you are not well or your client was
Client is at Kerala.
on the ground that still he is in Kerala. On the ground that the appellant is unwell and is undergoing treatment. So, respondents, you are representing all the respondents, Mr. Chakraborty.
Yes, sir.
Respondents are represented by Mr. Chakraborty, learned senior advocate, who has not seriously opposed such prayer. Next paragraph. Time to file affidavit in reply stands extended by 2 weeks. Stop. Next paragraph. List the matter before the next available circuit, subject to convenience of the bench.
My lord, if it comments to your lordship, may not record my lord, that non-serious of this. It's not necessary.
time since April 2024. I have to file affidavit in reply.
That is why I am requesting, my lord, let it not be recorded. My submission.
Too much.
My submission is not necessary.
If any appeal.
My submission is not necessary.
Yes. I have directed my officer to strike it off. Yes.
Item number 26, the FMET WC 1 of 194, read item number 27.
Not today. ঠিকই ধরেছো।
25 to 27.
একই গল্প চলছে।
Yes, 26 not today. Next.
26 and 27.
26, 27, 27. Yes, not today.
Item number 28, there is DB of 124.
For the state lordship appeal against Calcutta lordship under POC Act. Special leave to appeal is pending. There was a direction to file an affidavit in opposition. That has to be filed by the.
So special leave to appeal under section 378, subsection 4. Yes.
1B. So that is pending, lordship, because the respondent intends to file an affidavit in opposition. That is pending. It's not
I need to file.
Preparing for the husband file. We used to have a affidavit opposition for the husband. But there is difficulty on the use it.
Poison. Complaint case.
Lordship, SC case, government case. The respondent was a junior engineer. For clearings of bills for road construction, he has taken some time. The charge was filed under section 7 and 13 of POC Act, lordship. After conclusion of the trial, he was acquitted. The state has prepared an appeal against that act. Section 5 already allowed, lordship. Only the special leave to appeal has to be granted thereafter.
So special leave to appeal was granted.
Not granted,
Not
lordship. That is pending. They intends to file affidavit in opposition because they have an objection. Regarding.
What objection you were taking?
It's a clear equitable case now, for that isn't, this appeal should not be admitted, for that reason we.
Why? What? What are the grounds on which you are objecting?
My lord, message is appearing, my lord. I'm
Not today, come back.
My lord, I was instructed that we could not able to file the evidence opposition to the result that the accused is admitted in mainland, my lord. He is due to kidney failure. For
Where is he staying now? Accused?
now in mainland. Now in mainland. So.
Mainland means
Mainland in treatment.
Mainland.
Mainland. So,
in mainland.
mainland. Maybe next second.
When the. Show me that he is in mainland, any document in support of the same?
I provide one. In the course of.
Not today. Not to let us see. For an application under section 378 subsection 4, for such a long time, there is no need to keep this issue pending for such a long time. Unless until you have a valid objection against the application seeking leave to separate it, against the order of the application.
Item number 29, WPCT 19 of 2024.
Is very for the petition, my lord. And I pray that can be the day after tomorrow, Wednesday.
Not today, not tomorrow, day after tomorrow.
Continue. Okay.
You have to produce supportive documents.
My lord.
That he is in mainland.
For his medical purpose, yes, treatment.
Item number 30, WPCT 28 of 2024.
My lord,
Yes, I'm
I
appearing.
appear with Mr. Prasad for the respondent.
Matter is required to be heard.
We had taken
Whenever.
time because the respondent had undergone a surgery. over here. The respondent, the vice respondent. He had undergone a surgery.
You are
He was-
representing the respondent original petitioner.
Now the situation is resolved. We filed the Vakalatama today. Because he was admitted, I could not get the Vakalatama without which I was hesitant to address it. Now that has been filed, matter can be taken tomorrow.
Whenever, my lord.
There's a matter arising out of pension. This particular person was the subject matter of several departmental inquiries, some criminal proceedings. Very things are there.
Those proceedings and departmental inquiry were ended.
Some of them are ongoing. So he had prayed for provisional pension, which was initially allowed, later recalled. Over that, he had gone before the CAT. The CAT directed a decision to be taken by the Lieutenant Government. The Lieutenant Government took a decision that he can't be given anything. Against that, again, he went to the CAT. The CAT said, this is the whole point of provisional pension. That he has to have some sort of subsistence, like there is a subsistence allowance when he's on suspension.
When the proceedings is pending, some more disciplinary proceedings or criminal proceedings pending. Normally, provident fund amount is paid. And provisional pension, is there any bar, express bar in the rule?
My lord, there's a, we are relying upon Supreme Court.
So this is so
No, no.
far as the central rules are concerned.
we are-
Yes, CCS rules
The
are
matter
also-
had,
It provides for it. Now the CAT has passed an order accordingly, challenging.
In the
that
first
matter.
occasion,
Second occasion now, the
Second.
CAT has said that the Lieutenant Governor's order is incorrect and has directed immediate release of the pension.
sir,
Against that, this order.
Against
because
that,
we are relying, my lord, the parties.
Therefore, we need to hear.
Yes, my lord, the
Yes, so
parties
that's why-
had travelled up to Supreme Court, my lord. The Supreme Court had passed an order
In this matter,
in these
No.
very, not in proceedings between the same
not on
parties.
the same issue.
No, the issue was different then, but my lord, the matter was settled before the Supreme Court. And Supreme Court passed certain directions, which according to us justify the order which has been passed by the Lieutenant Governor. The other side is of course reading it differently. So my lord, that needs to be placed before your lordship, my lord, and whether our interpretation is correct.
To be able to come.
Whenever-
Because the pension issue.
tomorrow. is-
Whenever you pleases your lordship, we are available.
And the Supreme Court judgment, the copy.
It is annexed to
It's
this
part of
page.
the
It is
record.
part of
the
page 61. Page 61.
Which judgment you are relying?
Order passed, my lord, page 61. It's not a judge.
In a proceeding
Proceedings
which I was
between the
facing-
same parties. Page 61.
Proceeding I was facing was carried out to the Supreme Court. The Supreme Court permitted me to be voluntarily retired.
Page
But
60.
all the other proceedings would remain alive. And the court said all the issues of pension, that is a permanent pension, will be decided at the appropriate stage. Now, what they are trying to say is. since the
No,
proceedings
kindly
are-
see page
The
60.
order passed by the coordinate bench.
No, my lord. Sorry, my lord. Page 61 of the
This order starts from.
Not
page
61.
61, my lord.
Yes.
51.
So of the order which you are relying upon. So for the petitioner is concerned, it's a sheet anchored. So for your case, it's concerned.
No, it would not. be a sheet
Not
anchor.
paginated,
It will
my lord, it is My lord, in fact, my brief is also not paginated, I find. My lord, check the page,
No,
It is
but
part
our-
of the record.
Application.
It is an order dated 9th March. If my lord receive the index, kindly have 9 March 2022. That is annexure P7, it should be page 68. Page 68.
Yes, start, page 68.
Yes, my lord. P7.
Yes.
Yes.
Just open it up.
The proceedings which travelled up to the Supreme Court, my lord, the private party had challenged the jurisdiction of the Lieutenant Governor to act as disciplinary authority over him because it was his contention that he is an employee of the Zilla Parishad. And Zilla Parishad is a Panchayati Raj institution. So this honorable court division bench and single judge had held that the Lieutenant Governor cannot act as a disciplinary authority. However, my lord, the contention of the administration was that in the peculiar Panchayati Raj institutions existing here, Lieutenant Governor has pervasive control. Now, the Supreme Court has observed that the finding of the Honorable High Court on this question of law is incorrect. I mean, there is an observation, although it's not a detailed discussion, there is an observation. But the Supreme Court accepted this settlement, my lord, which was proposed by the parties before the court, that which your lordship will find in this order. However, the release of the benefits, etc., was made subject to disciplinary and disciplinary proceedings pending against him. Now, the whole interpretation is whether this disciplinary proceedings only means proceedings which were already where charge sheet was already issued on the date when this order was passed, or it also includes proceedings which were in contemplation or which are offsprings of those proceedings that were there when the Supreme Court passed the order. So, my lord, that is broadly the issue, but my lord, we'll have to then, of course.
With respect, I would disagree slightly. That's not the issue. The issue here is interpretation of whether, when the Supreme Court said benefits, whether the word benefits and this thing, gratuity, whatever, will include provisional pension. That is the issue, not about pending proceedings. Pending proceedings, everyone knows there are pending proceedings.
If CCS rules provides that in the event on the date of retirement, if disciplinary proceeding or criminal proceeding is pending against the income. In that event, whether
He would be
pension is
entitled.
payable or what are the
He
benefits
would be entitled to provisional pension. That
in
is the
terms of the rules?
I will show you.
What are the benefits which are payable to the income?
So far as the gratuity and the provident fund issues are concerned, those are part of the retirement benefits. That is a separate issue. But so far as the provisional pension itself is concerned, that is rule.
Because my lord, the Supreme Court's order says all consequential benefits. So, my lord, relying on that, the Lieutenant Governor has said that all benefits can be paid.
So the question is,
going beyond the purview or which is not permissible or which the rule permits to make payment, whether Supreme Court has restrained the authority from making those payments also.
That is why
Which are payable in terms of the service rules relating to release of. Benefits.
That is what we have to address, your lord.
Is it your case, Mr. Chakraborty, that the Supreme Court has restrained the respondent authorities from making payments which are payable in terms of the rules?
My lord, I will only be making an effort to defend the order passed by the Lieutenant Governor whenever your lordship fixes it.
Tomorrow.
Whenever your lord.
Tomorrow.
I will continue.
Manjita Kumari complete.
Next.
Item number 31, WPC 34 of 2024.
Lord, I am appearing for the private respondent, my lord. I see for the.
Mr. Sabir.
Mr. Sabir is appearing for the writ petitioner. Mr. Sabir is appearing. Where is he?
not seeing him today.
Not today. Not. Tribunal application of.
My lord, single will be taken up.
Just after 10
Mine.
minutes.
This would be the usual situation, right? The division bench list is exhausted.
Man,
It's a matter of contempt, my lord, passed by Honorable Justice Nizamuddin. But this will come to this, man. So
First time you heard or you have heard previously?
it would be second time, my lord, but it was placed before Justice Amrita Sinha, wherein Justice Amrita Sinha directed the registry to place the file before Honorable Justice Nizamuddin. But Justice Nizamuddin got retired from service, so the file is with registry only. No orders were passed.
The judge is not around, the judge is not there.
Yes,
The judge is not there. It is there.
Yes, ma'am.
Or transfer or elevation.
Yes, ma'am. Ma'am.
Then this matter should be run by the bench.
Yes, ma'am.
Having determination to take up those contents. Where judges have retired, those contents arising out of the orders passed by the judges who have retired or transferred or anything.
My lord, for that in a circuit bench, the matter, there's one notification, my lord, I can. Yes, ma'am.
It happened, I mean, I think pretty much on. On 31st, January.
Yes, ma'am.
You mentioned.
Obliged.
Mentioning on the list. Item number on WPA 36 of 2025.
My lord, I will be appearing on behalf of all the respondents.
Similar order was passed in other rate petition. Same issue is there also. What is the? Yes. Please, Lord. No order. Representations are pending before the order. That is to be decided by them.
Demand justice notice, page 30. My lord, Deputy Commissioner. Deputy Commissioner, North and Middle, it is 5, respondent number 5.
Yes.
My lord, it will take some time because resurvey has already been initiated, but it will take around 6 months. It will take, my lord, because it's a question of, I think, 79 families. So everybody has to be shifted to the reserved area because they are encroaching a forest area.
Now they are paying for subdivision of the land
Remember?
in their favor.
Minor. So it will take some time. Because so other villages are also there. So I think there are other cases are also there for allotment of number of cases. I think 1,000, maybe of 1,000 or 1,000 in numbers. So it will take time. All the respondents. Since affidavit has not been called for, the allegations level. Obligation.
Item number 2, WPS 37 of 2025.
I appear on behalf of the respondents.
One RC case is pending on the Tahsildar post. Without any date, it's pending. I want disposal of that case.
It's not pending.
The revenue case initiated for mutation of the proceeding.
Already we have initiated, my lord, page 21, my lord.
No, that is, but thereafter no date has been given. My prayer page 8. Page 1, 3. Page 21 notice was issued.
Notice was issued, my lord.
After 20, no date.
We have, even a page 18, my lord, we have taken initiative, my lord. We are not sitting tight over the matter. We have, published the notice also in the newspaper. That is at page 18.
By the authority, whether that right is there. Also, by which is concerned for property.
My lord. It is there.
What you are paying for?
Paying
Like,
for-
this is what
Is to decide the right of the party.
Mutation.
Mutation.
Mutation proceeding is pending.
How the cap is what you should not that hearing was scheduled on the.
Yes.
On that day, nothing was done.
No.
Thereafter, no date has been given.
What is the reference to the page 21, there is nothing that we initially discussed on the claim of.
That is, we appear page 22, when no objection was submitted by one of the reference given, RC number 1479 of 2020. Tahsildar.
Respondent. It's respondent number one. Only one, sole respondent.
Lordship, want to submit something. There's a case pending in the civil law court regarding this
Land in question.
this there's a dispute of the bill. They have the petitioner has plaintiff has challenged for the bill. This is a case of distribution of land to this petition. There's a bill is in
So
dispute.
you are against the settlement of land in favor of the.
Yes.
Since you have challenged only.
Yes.
And what is the status of their challenge?
This case is filed in October. Now, next date is on 14, so it is still in 14/2. Next one, SR and appearance. The party has received the copy.
Then why you have not added also?
Lordship, my prayer is let the Tahsildar heard them also and decide the matter, because civil court has no binding. Civil court has not got any restrict order.
That challenge is. How that is
No,
addressed by the respondent.
No, Tahsildar is competent as per the order. I enclose the order of the division bench of this court. Find this, he cannot keep that matter pending when the civil suit is filed, page 30.
But the dispute is still between the parties.
Same issue.
Otherwise, how?
Kindly come to once page 30. Page 30, division bench order of this court. When the issue was seen was there.
At the plenty in that it was.
Yes.
I will copy the situation.
Well,
Grateful. Sajita Kumari on behalf of Advocate G. Mini. Sajita.
Yes. Sarita Kumar is on your seat. As per your name. Submit it. That in understanding the management question. Next paragraph. On the other hand, upon the respondent, with regard to the application.
WPS 39 of 2025.
I'll be appearing on behalf of the respondent.
My lord, senior advocate Mrs. Nag is appearing on behalf of the petitioner, my lord. As the senior is out of station, my lord, so on 28th evening, my lord. So let this matter be fixed it on 29th, my lord.
Hearing of this matter stands at.
बोल देना उसे तो मैं करना पड़ेगा मेंशन करना पड़ेगा हाँ उनको लगा छुपाएंगे बता
Item number 4. Number 5, 7 of 2025.
Item number 4 and 5, my senior is appearing for the respondent authority. Declare this matter may be on next circuit. It's out of station.
In such case, the interim order, which would cease to operate from 1st of March, needs to be extended. my lord. Lord, this is for the second time I'm before this court. I am a encroacher of a piece of government revenue land. And my lord, in this island, my lord might be knowing, encroachers have certain rights. But without due process of law, at the first instance, effect of dispossession was given. Approach was made to this court. Certain interim protection was granted. The matter was relegated to the authority to take a decision. Now decision has been taken which are challenged in the present writ petition. And this court, while admitting the writ petition, has extended the. Lord, it was unjust. By just. My lord, the first order before Justice. It was on the very first day. The interim order so granted by her ladyship was extended even in the second proceeding. No coercive steps were directed to be taken. Lord. By this court, my lord. It was time to time extended. No, there are other orders. My lord would see the last order. No, this is the first one. The last order, my lord would see the interim order is. My lord. No, my lord, the order which I have challenged is dated 10th of June 2024. No, 5th February was the order which in the first round, my lord would see page 31 of the writ petition. Her ladyship, while disposing the first round, have granted some interim protection that was extended in the present second proceeding. My lord would see page 32, the operative portion, passed by her ladyship. Last but one paragraph. Yes, which is challenged in the present tense. Lord. Yes, my lord. Since I am in possession of the land in question, so such interim protection. I have to file my reply, my lord. Lord, I can file because the other side is seeking time till next circuit. If it is coming in this circuit, I can take time, my lord. I can file it. Because my client stayed at Diglipur, I can file it. Or even without reply, I can argue with the matter. Without reply, I can argue the matter also. It ought to have been under hearing, absolutely. Yes, absolutely. 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 Absolutely.
So when this time when the interim order has expired.
Now it is operating till last day of February, last order of 2025. Last order may kindly be seen, it would be operating till from 1st March, it would cease to operate. February 2020, last day of the February 2025. No, thereafter it was extended. My lord, kindly see the order passed by his lordship Supratim my lord Bhattacharya. Lord would find, my lord. But since other side will not, because I can file it, I will without reply also I can argue the matter, my lord.
Here is opportunity. In Calcutta,
When you come.
had instruction that he will come on next week, but it is not sure. That is the reason I am bringing for next week.
No.
accommodation is related on the level of response. On the ground of the matter, who is of the extension. Next paragraph. As a last chance, time to find activity time steps. Five. Here, January. This is the matter under the 18th. Now, 31st January.
My lord.
There's no.
My lord.
Need to extend.
My lord. I'm enjoying lordship. My lord, my lord, my lord, my lord, my lord, my lord. My lord, today, my lord, the reason, we all have to.
Not make it sit up to 4.
Attend lordship
We
that.
don't even notify. That's the practice, my lord, totally long back. Only for days, my lord.
Just accommodate for the day, my
For the
lord.
day.
There is one more incident occurred, we have conveyed, my lord. That is also a reason. So all the lawyers are remaining here.
Give it all.
Yes, my lord. Yes, my lord.
If any matter extension or.
Yes, that can be done.
Lord, I am for the petitioner.
For the respondent.
A similar matter is listed in court number 2. I mentioned the matter that will be listed tomorrow. So it will be taken up along with that.
My lord, item 7, my lord, they have to file the opposition. It's pending, not today. Yes, not today.
You do the matter, I'm ready to hear. You do the matter.
Tomorrow onwards, we are ready, my lord. We can do, or, yes.
Item 8, WPS 634, item 9, WPS 620,
Just stop it in.
item 10, WPS 647 of 2024, item 11, WPS 648 of 2024, item 12, WPS 647 of 2024, item 13,
May I
WPS.
please, my lord?
Yes, yes, I think.
Item 13, my lord. In this matter, I appear for the writ petitioner. There is a direction upon me to file affidavit in reply. But due to all of
You
sudden
want extension?
extension, my
Come
lord.
back tomorrow.
Tomorrow I shall not be available.
Appearing, my lord. I'm appearing for the item 13.
Tomorrow,
For respondent.
tomorrow I shall not be available. I'm going to Kolkata. That's why extension for 2 weeks, my lord, as petitioner mother was.
Option has been filed.
Yes, my lord. Yes, my lord.
So you are for the petitioner, you want to file a reply.
Yes, my lord.
Why these matters are appearing under the heading master, I don't know. After the direction for extending activity, the matter could be accommodated under the heading hearing. Not, it loses its identity as no term. Time to file application. Wait for on behalf of the petitioner, can extend it by. These are under the hearing. Under the hearing, before the next available subject to publication.
Deeply obliged, my lord.
Yes.
Item number 14, WPS 654 of 2024,
My lord, in this matter, Mrs. Nag is appearing.
item number 15, WPS 677 of 2024.
So item number 15, I am appearing, and the other parties also there. This is the
I'm
case
for
against,
the respondent number 1, my lord. Google India.
against the Google and Ministry of IT&T, because sir, I have a YouTube channel. Actually, I'm a 2024 Lok Sabha MP candidate. So I get around 4.2% of the votes, total vote polled in this election. What happened in
I'm representing Google India, my lord, and the advocate from Delhi is online before my lord.
Because I am appearing for respondent number 2 along with Mr. Rakesh Kumar Milot, because the petitioner had to comply with the order dated 7th January Milots. If I'm not sure if there was a direction to him to Milots.
Krishna, my lord.
Just a minute.
Please.
Yes, sir. I have submitted the affidavit of service also, sir.
But what about the implement of other parties selected by?
Yes, sir.
the court
Implement.
on 7 Jan?
Yes, sir. That also I have submitted, sir. Implement application, sir. Can application, sir.
No, it's not required to directly to the implement party and serve notice. Petitioner in person being faced with some difficulties submits to be including the private.
Yes, I have, sir.
Who claimed copyright of uploaded by you.
Yes.
By him based on the channel was dated. Now the copyright holder, whether they have been included as parties.
Yes, sir. I
Where
will.
is the, how you have included in the hospital of the petition?
Sir, I have submitted a can application.
For that, no application is required.
Okay, sir.
Court has granted you leave.
Okay.
You amend the post title, those copyright persons having copyright as party respondents and serve serve notice upon them.
Sure, sir. I'll just 2-3 days may be given because sir, I came all the way from Delhi. It is delayed, then I am facing difficulty to join.
No application is required.
Sir, I understand.
It is in terms of the order passed by the coordinated bench. You have to include them party
Sir, I'll.
and serve notice upon them.
Yes, sure, sir. I'll start to copy and I'll submit the affidavit of.
Yes, Mr. Ahuja, let the hospital of the institution be amended. In terms
Please,
of-
Milord.
It is required for that.
Please, Milord, we had already requested that, Milord, because the issue in this is there were copyright claims that were made by the third party uploaders, Milord, with respect to whose copyright content he had used in his videos, Milord. On basis that, Milord, the channel was terminated. So that is the reason, and on the last date, Milord, we had made that submission. Those copyright holders have to be party to the writ petition. Deholds the fact that, Milord, the writ petition per se, there is a challenge to the maintainability aspect, Milord.
Taken that will be considered at the time of hearing after the statement taken by the petitioner.
Please, Milord. I'll reserve my right to that effect. Plus, also we had requested one more, Milord. I'm so sorry to interject, Milord. One more request we had made that, Milord, he has implemented Google India Private Limited as a respondent, Milord. On the last date, Milord had directed them to substitute, Milord, Google India with Google LLC, Milord, because the platform YouTube is provided by Google LLC. That is a US based entity, Milord. LLC, Milord, Limited Liability Company, LLC, Google LLC. So, Milord, we have written in pursuant to that last order, we have written an email to the petitioner to make necessary amends in the memo, Milord.
We made as the respondent number 1 to describe the respondent number 1 in the constitutional property.
Sir, I understand. Actually, sir, I have made the Supreme Court judgment also. The Google LLC and Google India Private Limited, both are the same entity. They are the parent entity. They have established offices in India. So in the past.
So if LLC is described as respondent number 1, what is the difficulty?
So no difficulty, both are same because the unnecessary.
Technical issue. What is the difficulty if you describe respondent number 1 as Google LLC Private Limited?
No, Milord, only LLC, Milord, not private. Please.
No, sir,
Milord, the platform is provided by, Milord, the Google LLC, that is the US entity. YouTube is not provided by Indian entity, Milord.
Google LLC.
Please, Milord, youtube.com is provided by Google LLC.
Cannot be added as respondent number 1.
Milord, we had requested to substitute, Milord. Google India can be substituted with Google LLC, Milord. I'll place orders on
One.
Sorry, Milord.
Petitioner does not want. Petitioner appearing in person does not want.
Milord, if he will not file an application, Milord, I'll move an application. It's a request, Milord. At the end of the day, the relief he is seeking only if Milords may pass an order, it is only Google LLC that can comply with those orders, Milords, not the Indian entity. So that is what Milords. That is the only reason, Milords. If we unnecessarily, then we have to move an application.
Sir,
Petition fails, then
Sir,
it is your
Information Technology Intermediary Act says that whatever the office is there in India, they are liable. Then why should I make that LLC, Google LLC office in USA? Why should I make that party as an office? Because India, whichever officer they are present in India, they are subject to the laws. So they are forcing me to change the cost title and making other party.
Respond number one, Mr. Ahuja is online.
And what about this one, what we see?
Sir, I have served to the again the copies and I
And respond. Raise for application. Take steps in terms of the order to get civil general for amending the petition. And private parties. Who claimed copyright of the material uploaded by the petitioner. Stop. This steps to be taken by the petitioner by selling to amend the posted bill and additional responses. Stop. After amendment is carried out, after amendment is carried out, communicate. The petitioner is serve notice upon the additional response. Enclosing petition and the order passed by the secretary. By 7 days thereafter, service.
That's short time because I came all the way from Delhi.
By fortnight.
That's one Supreme Court order is there. Actually, what happened is
By fortnight thereafter.
That's
stop. Affidavit of service shall be filed on the next day. This the matter before the next available circuit. Subject to convenience.
Obliged.
Sir,
Grateful.
The Supreme Court order.
Please states first admin.
Sir, it will be.
Item 16, WPS 689 of 2024. Item 17, WPS 619 of 2024. Item 18, WPS 692 of 2024. Item 19, WPS 696 of 2024.
My lord, this matter, my senior, in item number 19, my senior is for the petitioner, my lord. There was a direction upon the petitioner for taking steps for impeding.
You were ready or you are seeking time?
Time, my lord. On
Not
fourth-
today, not
fourth-
today, come back tomorrow. Yes.
Item number 20, 703 of 2024. Item number 21, WPS 709 of 2024. Item number 22, WPS 714 of 2024. Item number 23, WPS 720 of 2024. Item number 24, WPA 8 of 2025. Item number 25, WPA 10 of 25. Item number 26, WPA 12 of 25. Item number 27, WPA 13 of 25. Item number 28, WPA 14 of 25. Item number 29, WPA 18 of 25. Item number 30, WPA 19 of 25. Item number 31, WPA 707 of 2024. Item number 32, WPA 7 of 2025. Item number 33, WPA 15 of 25. Item number 34, WPA 16. Item number 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 57, 58, 59, 61, 62, 63, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76,
77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117, 118.
118, my lord, is my matter. This is a writ petition which is ready for hearing regarding the IOCL distributor. I am an Indian gas distributor. Lord, my lord, I was praying for some updatation because I had an interim order which had been vacated. Thereafter, the matter went to the. I'll come back.
119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129.